Sorry. Are you?
Go ahead.
I appreciate that, but I guess what I'm a little surprised about with the government's hardline position is that I can't quite figure out whether you are sticking with the contracts idea or not. You've said many, many times that this is about the bargain and the government is bargaining not to litigate, and that's what we really have to care about. But as Ms. Blatt points out, every contracts regime that I'm aware of has some exception where the court is looking at the fairness of the bargain, where there's some consideration of the different degrees of ability to negotiate, the fact that you might have people who are being coerced into accepting this kind of deal, even though it's not knowing and voluntary. The court is policing that. And the government's position here seems to be that we are not supposed to be caring about that. We just need to focus on the fact that the government has made this deal, that it's not going to want to litigate any more of these cases. And so it kind of brings me to Justice Gorsuch's original point. Like, that seems kind of unconstitutional in a way, that the primary value here is to prevent the government from having to litigate appeals when we're talking about people's constitutional rights. And so I'm just trying to understand, is it your position that notwithstanding the contracts-like nature of this endeavor, we are not to be treating this the way the courts ordinarily treat contracts, which is to consider these kinds of exceptions?
So I'm really glad you asked this question, because I think this is a really important point for us. Our position is not that contract defenses do not apply to plea agreements or to appeal waivers. It is that the contract defenses that petitioner has raised here fail. They fail because a subsequent sentence that a defendant receives under just ordinary principles of contract law, the ones that petitioner has relied on here, do not make the agreement against public policy or unconscionable.
Right, but wouldn't you have to do that at an individual level? Like, I don't know how you could categorically say we allow for these defenses, but they're never going to apply in this situation, because something like the fairness of an agreement really takes into account what's going on with respect to that particular case. So this is why Justice Kagan is I think resisting the granular statement of what counts as a miscarriage of justice, because we could look at a particular case and say this bargain, this scenario is unfair, because it relates to the kinds of things that my colleagues have pointed out, right?
So if we're in contract world, and I'm going to bracket the miscarriage of justice world, which I think if this court's going down that road, it's not on the basis of contract doctrine, it's something else, some other kind of policy making.
No. Well, let's fold the miscarriage of justice concept into something like public policy, because you agree that public policy is an exception, right, under the contract world, and one would think that if what is happening here is a miscarriage of justice, we would say that that's against public policy. So let's put it under that umbrella.
Sure, I'm happy to talk about public policy exception. Under contract doctrine, again, I'm assuming we're in contract world. Under contract doctrine, the question is not whether the sentence is against public policy. The question is whether the agreement is against public policy. And the agreement to waive your right to appeal is not against public policy. It's not against the public policy of the appeal right statute. Because the policy of the appeal right statute is one of defendant choice always. And it's not against the policy of the underlying, say, constitutional amendment you say is violated.
What about the Sentencing Reform Act, which says that appeals are important, that they incentivize the court and the parties to actually follow the law, follow the guidelines, not issue these egregious sentences, right? We have a congressional policy that, in fact, revamps the entire sentencing system to allow for appeals. So to suggest that an appeal waiver is not against public policy, I think runs up against all of that.
But again, our system still, even after the Sentencing Reform Act, leaves it as a matter of defendant choice whether to exercise that appeal. If Congress really thought that the appeal...
That's the question today. That's my question that everybody else has given up, but I'm still working. My question is, should it be left as defendant choice, given all of these problems, given the fact that it doesn't seem to advance anything other than the government's interest in not wanting to litigate, these kinds of issues? Should it be left to defendant choice in this circumstance?
It definitely should, given that Congress has left it to defendant choice. I don't see a basis for this court to upend that. And then as to the idea that all we're doing here is protecting the government's interest in finality, no, I mean, this is a bargaining chip for defendants. The appeal waiver is valuable for us. So here, a deal with an appeal waiver was worth dropping 9 charges for petitioner. I have no idea what a deal without an appeal waiver would be worth, but basic economic logic suggests it would be less. Different charges.